Hello friends. Today we're going to discuss about principles and practice of forensic psychiatry. I'm Dr. Suresh Bada, Professor of Psychiatry working at NIMANS, Bangalore. Before I start my presentation, I would like to place this disclaimer. This presentation is for academic and training purpose only. This video is not for professional legal opinion or clinical opinion. For professional legal opinion, please do contact an advocate. For clinical opinion, please do contact a psychiatrist or a forensic psychiatrist. Conflict of interest? None. In this video, I'm going to discuss about principles of forensic psychiatry, what are the ethical dilemma in forensic psychiatry, and the dual role played by the psychiatrist and how it will come in the way of providing expert opinion. This video is targeted to the psychiatrist, forensic psychiatrist, junior residents, registered medical practitioner, nurses, mental health professionals, forensic professionals, forensic psychologists, advocates, and judges. Let's define forensic psychiatry. Forensic psychiatry is defined as the branch of psychiatry that deals with the issue arising in the interface between psychiatry and the law. This is the very simplest way of defining forensic psychiatry. But however, American Academy of Psychiatry and Law has defined it in a different way. It is defined it as a subspecialty of psychiatry in which scientific and clinical expertise is applied in legal context involving civil, criminal, correctional, regulatory, or legislative matters and in specialized clinical consultation in area such as risk assessment or employment. This is a very comprehensive definition given by American Academy of Psychiatry and Law. Let's spend time in understanding this definition. This definition clearly said forensic psychiatry is a subspecialty of a psychiatry. Okay? And it also talks about the applying of scientific and clinical expertise applied in the area of legal context, especially with regard to criminal law, civil law, correctional, regulatory, and other legislative matters. And it is the branch which is arising out of the psychiatry and also in clinical areas which is required for the assessment of risk assessment, especially violence assessment, or even purpose of employment. This is the best definition which can be given for forensic psychiatry. Now let's understand the comprehensive forensic psychiatry. That means it has three important areas. First one is mental health care related. That means here you will be talking about how a mental health care is delivered. How do you admit the patient? Whether the consent is not taken or taken. If it is not taken, what are the legislative matter? What is the duty of care? How the treatment is given? How the consent is taken? If the patient is not able to give consent or he doesn't have capacity to consent, how the consent is procured from the family members or the guardians, follow-up and community treatment. So this is the number one. Second, the civil responsibility. This is with regard to testamentary capacity, that is, capacity to make a valid will, whether a person with mental illness can enter into a marriage related to divorce, adoption of a child, whether a person is able to enter into a contract, transfer of property, and fitness to duty. So this is the second important. Moving to the third, it is the criminal responsibility. That is fitness to stand trial or criminal responsibility, whether the person is responsible for the crime, especially a person with mental illness. That is insanity defense. That is what we are discussing. And in India, we do not have this diminished responsibility, but however, the diminished responsibility is applicable in European countries, in some of the countries where the person claims to have mental illness or he has mental illness to avoid the capital punishment, it is applied here. Along with these three, the other important area which is coming up is prison psychiatry or correctional psychiatry. This is providing care to a person with mental illness inside the prison. Actually, there are various studies which clearly have said that mental illness is highly prevalent in prison setting. How do we provide care in prison is prison psychiatry. With this background of forensic psychiatry, which comprises of how do you provide a care for a person with mental illness in an institution or in the community, that is mental health care related laws. Second one is civil law, another one is criminal law. Now let's understand the difference between clinical psychiatry and forensic psychiatry. As you know by the definition, clinical psychiatry is a general psychiatry, but however, forensic psychiatry is a subspecialty of clinical psychiatry. That means to become a forensic psychiatry, you need to know first clinical psychiatry. That means the basic minimum qualification is after doing MBBS, you should have done MD psychiatry. After doing MD psychiatry, you need to do specialization in forensic psychiatry. Now let's understand what is the other differences. As I mentioned, clinical psychiatry means it's a general psychiatry which has 3 years course in most of the countries. You need to do that basic. After that, you need to do a subspecialty training, extra training you have to undergo. That is forensic psychiatry. That means all forensic psychiatrists are clinical psychiatrists. But all clinical psychiatrists are not forensic psychiatrists. That means clinical psychiatry is the first step to qualify and then move to become a forensic psychiatry. That is one. Clinical psychiatry is the basic training is required, whereas forensic psychiatry is the advanced training. Moving to the clinical psychiatry, many a time the court, the lawyers, and the population believes the treating psychiatrist is the best to give expert opinion. But unfortunately, in forensic psychiatry, when a treating psychiatrist gives an opinion, invariably it is biased. For a simple reason, if you are the treating psychiatrist, you have empathized, you have a bonding with him, you have a good therapeutic relationship. In such a scenario, you will err on the side of providing an expert opinion in the benefit of the patient. Hence, they say the expert opinion should be given by a forensic psychiatry. This is, I'm not telling it is American Academy of Psychiatry and Law. They say that. And invariably, the neutrality is very essential. Hence, they say the clinical psychiatrist should give opinion regarding the presence or absence of mental illness. Whether a person, because of his mental illness, he did not have the reasoning power or logical explanation, or he did not know the nature of the act, consequences of the act, and or contrary to the law, that needs to be given by a forensic psychiatry. In clinical psychiatrist, his area of working is in the hospital, whereas forensic psychiatrist will work in the area of prison, correctional setting, maybe private, or else even a forensic setting, in a highly contained forensic setting where the persons with mental illness are kept. In clinical psychiatry, the client is the patient. That means your obligation, your ethics, completely towards the patient. Whereas in forensic psychiatry, it is the third party. Third party may be the court, maybe the advocate, or the accused who is asking for your opinion, so that you give your opinion in his favor. That means in forensic psychiatry, the client may not be the patient. Second important, confidentiality. In clinical psychiatry, the confidentiality is prime. Whereas in forensic psychiatry, confidentiality is relative. You are under the obligation towards the public also. Under the oath and under the law, you need to disclose information to the law, that is mainly to the judiciary, only to the relevant information to the relevant people. That means you will be breaking confidentiality. In clinical psychiatry, empathy plays a crucial role. But in forensic psychiatry, there have been arguments saying that empathy comes in the way of assessment and giving opinion in the court of law. So these are very important crux differences between clinical psychiatry and forensic psychiatry. Further, in clinical psychiatrist, the aim is to treat the patient and rehabilitate him. In forensic psychiatry, you need to be honest. Your important prime responsibility is towards the public. Hence, your aim is to deliver justice or assisting the judiciary to give justice. Here, in clinical psychiatry, you need to take consent, to collect information, to diagnose, and to treat. Whereas in forensic psychiatry, your responsibility is to collect all possible information, maybe FIR, calling the survivors, calling the victims, all witnesses to collect information. Here, you may not need, especially in many countries, the consent of the client. Whereas in forensic psychiatry, you can do this without the consent of the client. Or else if the court has given you an order to provide an expert opinion, That means you need to make all efforts to get the collateral information from all possible sources. In clinical psychiatry, individual rights prevail. That means the patient rights prevail. The persons with mental illness rights prevail. Whereas in forensic psychiatry, the collective rights or the public rights or the community rights prevail. That is the way the forensic psychiatry has been dealt. So let's understand what are the principles of forensic psychiatry. Till now, we have discussed about the difference between forensic psychiatry and clinical psychiatry, the definition of forensic psychiatry. But however, the forensic psychiatry has certain principles that you should know before you enter into the area of forensic psychiatry. Let's move into one of them. First one is principle of sanity. Here, in forensic psychiatry, whenever a patient is referred or a person is referred for assessment, you will start with clear mandate telling that everyone is sane unless contrary is proved. That means any person who has been referred from judiciary or he has come for forensic psychiatry opinion, you will start with the dictum or a rule of thumb telling that everyone is normal unless otherwise it is proved. That means you will start from normalcy towards telling that he is insane if you are able to get the evidence. You need this evidence because in the court of law, when you testify, your certificate should be able to withstand the scrutiny of the opposite lawyer or else prosecution. That means you have to be very clear. You have to have evidence. You have to observe the patient or the client. You have to collect all possible information. You have to do ward observation. You have to do mental status examination. That means you will start from sanity and see whether the person is normal or abnormal by your own observation. That is principle of sanity. Moving to the second important principle, principle of mental capacity. That means, again, here also the rule of thumb says every adult, that means above the age of 18 years, has a right to make his or her own decision and must be assumed to have a mental capacity to do so unless it is otherwise proved. That means even if a person is referred from the court because of the Constitution of India, you will be saying every person has a capacity to decide. That means right to self-determination is there. He will decide for himself. That means you will be assuming every person has a capacity and you will take consent from them. That is what it is. You will not say that just because he is referred from the judiciary doesn't mean that he doesn't have capacity. That doesn't mean that you will not take consent. If you are not taking consent and you are violating the self-determination, that means you should be very clear. That person does not have mental capacity. You need to prove that. The psychiatrists need to prove that. And then you have to take consent either from the medical officer himself or else maybe the institute where he has been belonging or the person who has referred. Then only. Or the person, if he is in a mental health legislation is there, as per the mental health legislation, you have to assess the mental capacity. As for in India, Mental Health Care Act of 2017 is there. As per Section 4, capacity to consent, that is mental capacity assessment has to be done. And if he does not have capacity, invariably, you will be taking the consent from the nominated representative. So that is even if he is in the judiciary. Moving to the third principle, the principle of ignorantia juris non excusat. That means everyone is presumed to know the law, but that ignorance of law will not be permitted as an excuse. That means it is very clear. You cannot say that this person is illiterate, he does not know the law. No. By default, it clearly says everyone is presumed to know the law. Just because he is ignorant or illiterate, you cannot excuse him from his crime or his whatever the conflict of law. That is the third. Moving to the fourth, principle of deemed to be fit to stand trial. Again, here it is, you need to understand this. Every adult accused of committing a crime is fit to stand trial unless it is otherwise proved. That means any person is accused, he will go to the court. And in the court of law, he will be deemed to be fit to stand trial unless if there is a contrary, that he is a past history of mental illness is there or he has mental illness, then you have to observe him, you have to do the assessment, you have to have a diagnosis to say this person because of this mental illness or because of the brain damage or because of the poor intellectual disability or intellectual problem, he's not able to stand trial or he's not fit to stand trial. That means it is unless otherwise proved. You will be considering everyone is fit. Moving to the fifth important, start from null hypothesis. This is similar to the first one, but here there is no relationship between the conflict with law and the mental illness. Here you will say the null hypothesis. That means there is no relationship between mental illness and the conflict with law. Any person who is being referred from the court, judiciary, or from the forensic setting, or from the prison for assessment, you will start with the null hypothesis. That means there is no, the person who is being assessed, you'll be considering them as he's normal one, even if he has mental illness, because he's been in the prison, he's depressed, he's not getting bail, his court hearing is delayed, he maybe have mental illness. But still you will say, although he may have mental illness like depression, stress, that is not related to the crime. That means there is no relationship between mental illness and conflict with law. This is the default you will start. If you think, no, he has mental illness, that mental illness is directly causing a loss of reasoning, and because of loss of reasoning, he has committed a crime. If you have this, then you need to collect evidence for the researcher hypothesis. Here, it is a forensic psychiatrist hypothesis. So, this fifth important hypothesis you should remember and keep it in your mind. The important dictum is, first is he does not have mental illness. That is the way you'll start. Everyone is normal. But if you find there is a mental illness, you will move to the second. There is no relationship between mental illness and crime. And no, if he has, there is a relationship. That means you will collect evidence and do a thorough assessment. So no, during the commission of crime, he had loss of reasoning power. So that you need to be able to establish in the court of law. And it is the duty of the forensic psychiatrist. This is the fifth important principle. Moving to the sixth. Past history of mental illness is not sufficient to call for insanity defense. Here, if there is a past history of treatment or past history of hospitalization in a mental hospital, though relevant, shall not justify for having an insanity defense. You need to keep this in mind, because 2 years back he was admitted and he was diagnosed to have schizophrenia, and 2 months back he has committed a crime. Just because he was diagnosed to have schizophrenia 2 years back, that does not mean he will get insanity defense now. To understand that. That is, yes, it may be relevant information, but that does not suffix that he will get insanity defense, because insanity defense is very clear. Section 84 of Indian Penal Code clearly says that a person who is claiming to have insanity defense, that means he needs to prove 4 important things. That is, because of reason of unsoundness of mind, he does not know the nature of the act, he does not know the consequences of the act, and or contrary to the law. That means these 4 criteria he should fulfill. Then only he will get insanity defense. That means he should have mental illness. The mental illness should be occurred during the commission of crime. He should have severe mental illness during the commission of crime. And when he is committing the crime, he did not know the nature of the act, consequence of the act, and or contrary to the law. That means his logical reasoning is gone for a toss. That needs to be proved in the court of law to say he has insanity defense, so he can walk away. That is the principle number 6. Moving to the 7th. Mental illness does not mean unsoundness of mind. Here, presence of mental illness during the commission of crime does not mean unsoundness of mind. That means he does not have logical reasoning. That will not be considered. The logical reasoning should be tested. Just because somebody has mental illness, for example, I can give you is a person who is under the intoxication of alcohol commits a crime. That means because of alcohol, he has lost the reasoning power. Does it mean he gets insanity defense? No. Here, if he has taken the alcohol by on his own, and he knows the alcohol is going to create trouble in his judgment, and he has committed a crime, he will be responsible for it. Or else, one more example I can give you. Husband is beating wife. There is a severe domestic violence. The lady becomes fed up with that, and she takes the law into her hand and she kills her husband. Because of domestic violence, she has depression. But she stabbed him to death. She knew the nature of the act and consequence of the act. And also she knew it is contrary to the law. Here, although she had domestic violence and depression, that does not mean she will get insanity defense. That is the principle number 7. Principle of impartiality. One of the important qualities of a forensic psychiatrist is not being biased or prejudiced. Here, the forensic psychiatrist should maintain the neutrality here. Even if the assessment is going to be done, if he is accused of committing a crime against a child sexual abuse, after raping a child, he has killed the child. In spite of that, you will try to maintain neutrality. Even if a person with mental illness is accused of killing his mother, father, brother, and sister, even then, you will try to maintain neutrality. That is an important quality. You should maintain that quality, and impartiality should be there. From there, you will do your assessment thoroughly so that your observation is objective, honesty, and assessment will lead to the serving justice. That is very important. Moving to the 9th important principle, respect for human rights. Here, all forensic psychiatry should be non-participant in acts involving torture, inhuman, and degrading treatment. Invariably, the prisons or correctional settings sometimes, maybe rarely, may be involved in inhuman, degrading treatment or torture. Forensic psychiatry should not get involved in this kind of torture business. That is another important ethics one need to follow, and that is the responsibility of the forensic psychiatrist. Now let's look into how the forensic psychiatry and medical ethics go hand in hand, or is there a friction? If you look at the medical ethics, there are 4 important pillars. They are autonomy, justice, beneficency, and non-maleficency. Here, autonomy is respect for the person. That means he has right to self-determination or self-governance, self-rule. He will decide what will happen to him, whether he is inside or outside the prison. That is right to self-determination and self-governance. You will take consent either for admission, treatment, or any other procedures. Moving to the justice. Second important ethics, that is treat similar people in similar ways. That means whether a person is in prison or an accused person, you will have the same ethics for a normal patient who is not committed or conflict with law with a person who has been accused. That means even if he has convicted a crime and he is being punished by the court, you will maintain the neutrality and the justice. You will treat the person similarly in a similar way across the patient group. That neutrality has to be there, and that justice should be served by you. Moving to the third important, non-maleficency. Here, do no harm. Unfortunately, this is very difficult. In a forensic psychiatry, you have been ordered by the court to do assessment. And when you do the assessment, you may find that this person is malingering and he has committed a crime. And your certificate may put him to the gallows or to the behind bar. That means you cannot guarantee non-maleficency. That will be a big problem. Not only that, if a person has a severe mental illness, you may have to give medication, and medication may have side effects. Again, do no harm will be again a problematic ethics here, especially in forensic psychiatry. That is the third one. Fourth, beneficency. Here, in medical ethics, we say the doctor need to act in the best interest of the patient. In forensic psychiatry, you will be impartial, neutral, and your client will be either the court, judiciary, or maybe the advocate. Your primary importance is maintaining public health or public justice. So acting in the best interest of the patient may not be possible in forensic psychiatry. That means even beneficency may come in the way. So these 2 important ethics, non-maleficency, beneficency, may come in the way. Let's discuss if there are a conflict between the above ethics. We've talked about 4 ethics: autonomy, beneficency, non-maleficency, and justice. If there is a conflict between the 2, autonomy and beneficency, here the beneficency is, imagine you have to do an assessment, especially because of the court order. Unfortunately, the patient is malingering, and your assessment clearly says that he is malingering and he wants to evade the punishment. Here, whether I should act in the benefit of the patient or else in the benefit of the public at large. and your certificate will decide here. So now the problem is the person with mental illness or may not be having mental illness. Here the autonomy versus beneficency comes into play. In such a scenario, whether you will give a certificate telling that he has mental illness or you will say he is malingering. So in such a scenario, you have to uphold the justice. That is the role and responsibility of the forensic psychiatry. Moving to the autonomy versus non-maleficency. Here, if a person with mental illness has committed a crime and he's been referred here for his abnormal behavior, he has capacity but he is refusing to give consent for treatment. But he has severe mental illness. There is a possibility he may harm himself or others. Now the question is whether you respect autonomy or you will say non-maleficency, I will treat him against his wish and will. By taking the consent, or he does not give consent, I will take the consent of the judiciary or else the relevant correctional setting authorities. So these are some of the medical ethics conflicts which occur. Along with this, there are some issues in forensic psychiatry that need to be known, because many of the time the clinical psychiatrist will be doing justice in the form of medical ethics, but unfortunately we forget in clinical psychiatry there is a third party involved, that is public or else the victim who has undergone the crime or else the survivor of the crime. So what are those issues in forensic psychiatry? First and the foremost is confidentiality. In clinical psychiatry, you will maintain confidentiality 100%. But in forensic psychiatry, you need to reveal information to the court. Second, consent. Invariably, the consent is essential for admission. But in forensic psychiatry, even if the person has capacity, because of the court order, you may have to admit. You may have to give medication against his wish and will. There are some states, because of the order of the court, you may have to treat him. So that is again may come in the way of medical ethics. Coming to the third, risk assessment and incarceration. Imagine a person with mental illness has committed a crime. Unfortunately, no family members are ready to take him back. The court has clearly said that he has insanity defense or not guilty by reason of insanity is been given. But none of them is ready to come and take his custody and provide treatment. Now, when you do the risk assessment, the psychiatrist or a team of psychiatrists will say he's highly risk if he stops medicine. In such a scenario, the court may decide to put him in a forensic setting for his lifelong. In that scenario, whether is it justified doing risk assessment, putting behind the bar, considering public at large. So these are the issues which need to be answered. Further, many a time, this death row phenomena or death row syndrome has been used. This is again a concept where a person who has been given death penalty and it is not been executed and he is waiting for the death execution and is not sure when he is going to be executed. In such a scenario, that person may undergo anxiety and depression. And this phenomena has been used in many of the countries to avoid death penalty or else to get the mercy. But unfortunately, this death row phenomena or syndrome is not recognized by the International Classification of Disease 10 and also current 11 and even DSM-5. Coming to the next important, dual role, also called as dual agency. If a clinical psychiatrist is treating a person and that person with mental illness commits a crime, who should be the expert opinion? Is it the clinical psychiatrist or a forensic psychiatrist? This dual role again is a big problem and challenging in a country like India, where we have psychiatrists themselves are very less. And forensic psychiatrists have not crossed even the double number. They are less than 100 in number in India. So in such a scenario, whether we should insist only forensic psychiatrists should see or else accept the risk with the dual role or dual agency. That means clinical psychiatrist will provide the expert opinion and that can be biased towards the patient and that may harm the justice. This is again another important issue. Moving to the third, whether the clinician or the forensic psychiatrist should be the expert opinion. This is again a big role. And until we have enough of number of forensic psychiatrists across the country, this may be very difficult to implement. However, whoever is the clinical psychiatrist who wants to learn forensic psychiatry, there should be a course or a training which should be started at the earliest. Now moving to the clinical psychiatrist versus forensic psychiatrist who should be giving the expert opinion. As I mentioned, the clinician is in constant touch with the patient and he knows about the patient, he knows about the clinical information, but unfortunately, the clinician has empathy, he has a bonding That is a relationship between doctor-patient relationship, and he has a medical oath telling that he will do beneficiency, he will not do any harm to the patient. In such a scenario, he may give a certificate in favor of the patient. Although a person with mental illness has committed a crime, and that crime was done during lucid interval, the clinician may err on the side, okay, he is mentally ill. Let him not be punished. In such a scenario, that will be a big problem. By chance, even if the clinician is providing the certificate in favor of him, but the court finds that this person had logical reasoning and the court gives a punishment. Now, because of the punishment, the patient may lose the trust between the doctor-patient relationship. That means we have lost a therapeutic relationship. Again, this will be harming the patient. And at the same time, clinician may not be able to appreciate the legal construct and the procedures involved during forensic psychiatry. So there are both benefits and drawbacks. As per American Academy of Psychiatry and Law, they are very clear. For a forensic psychiatry opinion, it's the forensic psychiatrist has to. Clinical psychiatrist should refrain giving forensic psychiatry opinion. His opinion should limit to the diagnosis and management, not in the area and arena of forensic psychiatry. Since there was a medical ethics coming in the way of practicing forensic psychiatry, and there was a clear-cut conflict with regard to beneficiency and non-maleficency, there was a need to revise forensic psychiatry ethics. Hence, American Academy of Psychiatry and Law came up with a new ethics. But however, this was triggered by an event. The event was Alan A. Stone gave a lecture. That is, in the American Academy of Psychiatry and Law in 1982, he gave a lecture in that his critics nurtured a cascade of events, reaction, generated a thorough reflection of ethics in forensic psychiatry. Even Stone stated that forensic psychiatry stands outside the ethical limits defined by American Medical Association. Because he was very clear, beneficiency and non-maleficency cannot be done being a doctor. This was his critique. Further, he also stated that, in his own words, I am repeating, psychiatry prostitutes itself because it may as well harm justice and profit to the patient, or on the opposite, deceive the patient and profit the justice in the context of adversarial system. This is the words used by Alan Stone in 1982, and it has been published in a Journal of American Academy of Psychiatry and Law in 1984. Because of this conflict, at the same time, Alan Stone made a remarkable points which was criticized. At the same time, reflection occurred, and then the birth of new forensic psychiatry ethics occurred. Because, of course, medical ethics is there. Forensic psychiatry as an ethics definitely stands out, and it needs a separate ethical issues to be addressed. So these important 4 ethics were drafted. These were drafted by American Academy of Psychiatry and Law. What are those 4 ethics? First and the foremost, respect for person, confidentiality, honesty and objectivity, and fourth, required qualification to practice forensic psychiatry. Let's look each one of them. Respect for person. That means consent. The informed consent of the subject for forensic evaluation must be obtained. Even if there is a court order, you need to mention to the subject or the client that you are doing an assessment. If where there is a consent is not required, notice to be given to the evaluation or the evaluee or the client. If the client is not competent to give consent, you may have to take the consent from the jurisdiction of the law. That means a person who is in charge of the judiciary or maybe of the correctional setting, you need to take permission from them. That is very essential. The consent is must, but however, in certain situation, you may not be able to take consent. In such a scenario, you will follow mental health laws of that country or the area. Going to the second important, confidentiality. The psychiatrist has to maintain confidentiality, but however, in forensic psychiatry, it may not possible. But however, you need to thrive and maintain confidentiality. But given the legal situation, you need to examine. At the same time, you have to tell the client that In this forensic psychiatry assessment, I'll be submitting the report to the court. That means an evaluation of forensic purposes begins with the notice to the client of any limitation on confidentiality. Information or reports derived from the forensic evaluation are subject to the local legislation, laws, and rules. That means if you are able to get certain information, it is not 100% confidential. That means confidentiality is not absolute if it comes in the way of larger public interest or to serve the justice. In such a scenario, you may have to break confidentiality to serve the justice. And under the oath, under the obligation of the law, you may have to break confidentiality. That need to be told to the client. And if the client is not in a position to tell, that needs to be documented. Moving to the third important, honesty and objectivity. Forensic psychiatry evaluation and the application of the data obtained to the legal criteria are performed in the spirit of such honesty and efforts to obtain objectivity. Whatever the case, whatever the accusation against the client, he would have done a heinous crime, but you have to maintain honesty and objectivity. Your personal bias will not come in the way of your assessment. That is what is honesty and objectivity. Moving to the last, required qualification. The expert's qualification should be presented accurately and precise. And the expertise may be appropriately claimed only in the area of knowledge, skills, and experience and training. That means if you are a forensic psychiatrist, you need to mention about your expertise, skills, and experience, and your expertise should limit to that area only. You should not cross your limit. That is where the forensic psychiatrist starts and ends. To conclude, my dear friends, clinical psychiatrists need to understand there is a difference between clinical psychiatry and forensic psychiatry. One need to understand the basic principle of forensic psychiatry and the medical ethics conflict which occurs when you are practicing forensic psychiatry. If you're not aware of this conflict, invariably your biases will be towards the patient. Further, treating psychiatrist and forensic psychiatrist should be separate when a forensic psychiatry opinion is sought by the court. Although the clinical psychiatrist may be the best person to give opinion regarding the diagnosis and treatment. With regard to forensic opinion, forensic psychiatry is the best because he is neutral and he will not have any biases. Further, the person who is practicing forensic psychiatry should be aware of the new forensic psychiatry ethics. That is respect for person, confidentiality, honesty and objectivity, and required qualification. These are the very important differences you should know before you start forensic psychiatry practice. And you need to undergo training, experience, and know the local laws when you are practicing forensic psychiatry. Thank you very much for giving your valuable time. Stay safe.